All right. Welcome back to another episode of The Gift That Keeps on Giving, also known as the Delete Lawz LOLsuits. So there's been a flurry of activity in two of the cases. I'm limiting today's episode to just the Las Vegas case against the Las Vegas Metropolitan Police Department. There's there's been a lot in the California case. I think that would break me trying to read that. It's just it's nonsense, and I'm not ready for it yet. So with that, let's jump right in. How many of you remember that song from the 90s? I listened to it the other day for the first time in a long time. Quite a good song, even if it dates me. But yeah, so let's jump right into Decastro versus LVMPD et al. And as usual, best place to start is the docket. So last time we were here, which I think was also the first time we were here on this specific case, we looked at his motion to file electronically. That's a given. Did we? Okay, yeah, the advisory letter, consent for electronic service, that's nothing. Summons issued as to Bork, Dingle, Doolittle, LVMPD, all of those. The complaint, the case was randomly assigned to this judge and this magistrate, and the judge ordered that he would have pro se access to the CMECF filing system. So that's where we left it last time. So without too much, because what happens is sometimes if I don't get to things right away, which I'm not going to, some judges actually issue orders. Judge Burroughs might want to revisit that idea at some point there in Boston. But we do have an order on these docket entries, these motions, but we'll save that for the end. So what do we have? Docket 6, clerk's notice, basically saying Delete Lawz needs to file his notice of interested parties, and that is due tomorrow, since it's just past midnight on the 4th of May. So may the 4th be with you for all you Star Wars fans. It's not quite showing up on camera, but I am wearing my Abbey Road Star Wars mashup t-shirt. So that's just kind of a formality that he has to do. And then we have summons returned executed by LVMPD, which has problems. And then we have a motion for early discovery by Delete Lawz and a motion for extension of time to serve summons on plaintiff or on other defendants by Delete Lawz, and a motion for leave to file first amended complaint by Delete Lawz. And all of these are nonsense. They're at best premature. So with that said, let's jump in. And first document, proof of service. Maybe. So we have proof of service. This section should not be filed with the court unless required by Federal Rule of Civil Procedure 4I. This summons for Las Vegas Metropolitan Police Department was received by me on 4/24/2023. And the box is checked saying, I served the summons on they refused, who is designated by law to accept service of process on behalf of Las Vegas Metropolitan Police Department at 400 South Martin Luther King Boulevard, Las Vegas, Nevada, 4/28/2023 at 9:28 a.m. My fees are $0 for travel and $85 for services for a total of $85. And it would be nice if this would scroll for me. There we go. I declare under penalty of perjury that this information is true. Served by Teresa Augustin. So that could be problematic. Oh, and then there's slightly more. I didn't want to show the address. Apparently, the process server is from Los Angeles, but additional information regarding attempted service, etc. I delivered the documents to they refused, who identified themselves as the employee. The individual tried to refuse service by refusing to take documents and did not state reason for refusal. Documents left seen by subject. The individual appeared to be a gray-haired white female contact over 65 years of age, 5'4" to 5'6" tall, and weighing 160 to 180 pounds. So that's going to be a problem, I think, because they're saying I served the summons on this person who is designated by law to accept service of process on behalf of Las Vegas Metropolitan Police Department. Now, I guarantee there is a specified person working for LVMPD to serve. Whether that's the chief or the general counsel or whatever, there's going to be someone to serve. Serving a random employee in the lobby or a receptionist or whatever is not service. He wasted $85 here. So in addition, there are other issues with service. I'm not going to get into them because I don't want to give any hints. But when you're suing the government, there are other things you need to do. So this reminded me, though, I said we're sticking to the Las Vegas lawsuit, but this reminded me of something that happened in Texas. And oh boy, this one's funny. So this is in the United States District Court for the Northern District of Texas, Dallas Division. And the case is Eunice Lofty versus David Holman, Officer Smith, and City of Forney. So this is a case that I haven't covered, but I'm sure most of you, if you've been following Delete Lawz for any period of time, are familiar with the Eunice Lofty debacle. So Eunice Lofty was Deborah Rogers about 3 Deborah Rogers ago. He was involved in a car accident there in the city of Forney, Texas, and he was found to be at fault and sued, basically with Delete Lawz help. It was utter nonsense. So this is defendants Holman, Officer Smith, and City of Forney's 12B5 motion to dismiss for insufficient process and the brief in support. Now, this is one of the funniest legal documents I've read. I mean, this attorney did not turn the snark up to 11. He's at least 12 or 13 on this one. It's absolutely brilliant. And it's short. So, not going to read the whole thing. But starting on page 2, leaving his spurious allegations aside, the plaintiff's threshold problem is more glaring. Neither he nor his internet self-promoting custodian of the court, Jose Decastro, have properly served any of these defendants. And we'll get to the footnote 5 next to Jose Decastro. The fatally flawed service of these summons in a civil action is not only evidenced by even a cursory review of the proof of service, but further underscored by the very video posted online crowing about purported but clearly defective service. A copy of such video is attached here too as exhibit number 1. Through the botched handiwork of the plaintiff's cohort, custodian of the court, Decastro, the summons were simply dumped with administrative employees in the city of Forney's manager's office and a technician at the Forney Police Department. Footnote 6. Specifically, the summons were merely dropped off with Megan Killingsworth, the executive assistant to the Forney city manager, and Tamara Osborne, a records technician in the police department, neither of whom are authorized to accept federal summons, have it in their job description to do so, nor are they statutorily designated as a proper person for service on a governmental entity. Footnote 7. Indisputably, none of these summons were properly served on any individual defendant or a proper representative for the city of Forney, nor did anyone agree to accept service on the behalf of any of defendants. Footnote 9. The court should quash the purported service and dismiss without prejudice all claims against these defendants. Footnote 5. The proof of service are signed by a Jose Decastro with an address in Santa Monica, California. Presumably, he is the same person on the video. Throughout his video, Mr. Decastro spouts his personal skewed beliefs about the law and freely gives bad advice about filing and service of a federal lawsuit. He also curiously describes himself as a custodian of the court, in quotation marks. And then footnote 7, describing how to serve a municipality. Of course, this is in Texas, and this is Texas Civil Practice and Rem Code Section 17.024B. The state of Nevada is going to have something similar, I'm sure. In a suit against an incorporated city, town, or village, citation may be served on the mayor, clerk, secretary, or treasurer, not random gray-haired employee in the lobby, not receptionist. It's mayor, clerk, secretary, or treasurer. It's going to be the same in Vegas, I'm sure. So, footnote 8. Although proof of service form has been doctored to fit Mr. Decastro's curious actions during his service attempt, he marked, under penalty of perjury, that he personally served the individual officers at Forney Police Department and the City of Forney City Hall. And footnote 9. When attempting to serve the officers at the police department, Tamara Osborne can be heard clearly telling Mr. Decastro that the officers are not there. He leaves the 2 summons anyway. So, the legal standard, this is the important bit. Once again, this is going to be basically the same analysis, but with different case law citations in Nevada. So, a motion brought pursuant to Rule 12b-5 seeks dismissal based upon defective service of process. Under Rule 12b-5, defendants may challenge the method of service attempted by the plaintiff or the lack of delivery of the summons and the complaint. Once such a motion has been filed, the party serving process has the burden of establishing its validity. When a serving party fails to meet its burden, a court may exercise its discretion and quash the service and dismiss without prejudice all claims against the improperly served defendants. Argument and authorities. Plaintiff purports to have served the Forney defendants. However, plaintiff, through putative process server Decastro, just dumped the summons with administrative employees working for the city of Forney. Footnote 10. As previously discussed above and described more fully below, plaintiff's service of these summons is wholly insufficient. Federal Rule of Civil Procedure 4 establishes the procedure for effectuating valid service of process. To effect proper service, a summons must be served with a copy of the complaint, Rule 4C1, and plaintiffs must comply with the rules governing service of process according to the type of defendant plaintiffs seek to serve. C.e.g. Rule 4E, delineating rules for serving individuals, Rule 4H, delineating rules for serving corporations. Additionally, unless service is waived, proof of service must be made to the court in the form of the server's affidavit. Absent proper service of process, a court lacks personal jurisdiction over the defendant, and any default judgment against the defendant would be void. The federal rules do not permit service by leaving documents at a place of business, nor at City Hall. However, Rule 4E1 permits a party to follow state law for serving a summons. So we saw Texas state law for serving a summons on a designated agent of a city. The mayor, treasurer, secretary, or council, was it? Mayor, clerk, secretary, treasurer. So that's Texas Civil Code, but Rule 4 of the Federal Rules of Civil Procedure allows Texas cities to use this law even in federal court. Let's see. Absent proper service of process, a court lacks personal jurisdiction over the defendant. Okay, here. This is where I was. Permits the party to follow state law for serving a summons. Under the Texas Rules of Civil Procedure, a plaintiff may serve defendants by either delivering to the defendant in person a copy of the citation showing the delivery date and petition, or mailing to the defendants by registered or certified mail, return receipt requested, a true copy of the citation with a copy of the petition attached thereto. Here, plaintiff's YouTube colluder Decastro did none of this. Instead, he doctored the form proof of service, footnote 11, to try to contort his actions into valid service upon the Forney defendants, and in the process has now sworn to this court under penalty of perjury that he did so. The sophomoric and theatrical attempts playing to an internet crowd do not constitute proper service under the federal or Texas rules of civil procedure. Due to this inadequacy, respectfully, this court lacks personal jurisdiction over these defendants who have not yet been properly served. Accordingly, defendants respectfully request that the court dismiss the plaintiff's claims or, in the alternative, order the plaintiff to properly and timely effectuate service of process as to each particular defendant. So, and shout out Robert J. Davis of Matthews, Shields, Knott, Eden, Davis, and Beanlund, LLP. I love this motion. It's just, the snark is through the roof. But I foresee in the very near future, unless Delete Lawz cures it of his own volition, a very similar motion being written by the LVMPD about this proof of service, because they refused, and some gray-haired 65-year-old woman are not the mayor, treasurer, secretary. They're not the designated person to serve process on. Whatever the Las Vegas and Nevada laws are, like I said, I'm guessing it's almost identical because it just makes sense to do it that way. But the police department is going to have their own designated agent. It's, like I said, it might be serve the city, or county, because LVMPD is kind of structured funny, but it's probably serve the sheriff, because the sheriff heads LVMPD as part of its funny structure. It might be, serve the deputy chief for whatever. It might be serve the general counsel. It might be, you get the drift. There's going to be someone, not a random gray-haired employee that didn't identify themselves in the lobby, or receptionist, or that it's not them. So we're off to a great start. And even better, we have Delete Lawz, motion for early discovery, extension of time to serve summons, and for leave to file first amended complaint. Plaintiff Jose Decastro hereby moves this honorable court to grant this motion for early discovery required to name defendants, for an extension of time for plaintiff to serve summons once named, and for leave for plaintiff to amend its complaint with the defendant's true names pursuant to Federal Rule of Civil Procedure 1, 6, 15, 16, and 26. In support of this motion, plaintiff submits a memorandum of law which is fully incorporated herein. Facts. I'm always amused seeing a facts section in one of his filings, since I don't think he understands what a fact is. Plaintiff has visited the offices of defendant Las Vegas Metropolitan Police Department on multiple occasions, has made several telephone calls to LVMPD, has opened an internal affairs complaint with LVMPD. No mention that complaint was a wiretapped phone call. Curious. And has filed public records requests with LVMPD for the true names of all officers involved in plaintiff's complaint. To this date, plaintiff has only received refusals from LVMPD to provide the true names of the officers that responded to the incident that is the principal cause of this action. Plaintiff will be unable to serve defendants until he has their true names and addresses. LVMPD has the defendant police officers' true names and addresses, points and authorities. Federal Rule of Civil Procedure 26(1)(a)(1) requires that the defendants provide the name and, if known, the address and telephone number of each individual likely to have discoverable information. Very soon, anyway. Okay. I mean, yes. Just Federal Rule of Civil Procedure 1 allows the court to make orders to ensure the speedy and inexpensive determination of every action and proceeding. Therefore, let's ignore all the other rules because Rule 1, it's almost like the rest of the rules were enacted. Same with the rules of evidence in order to actually ensure the speedy and inexpensive determination of the actions and proceedings. Federal Rule of Civil Procedure 6 allows the court to make, for good cause, orders extending the time that must be done, that an act must be done. Federal Rule of Civil Procedure 15 allows a party to amend its complaint with leave of the court and that the court should freely give leave when justice so requires. He's missing a step there, but we'll get to that. Federal Rule of Civil Procedure 16 sets up the foundation for the court's powers to control the pretrial phases of complex litigation, including directing the parties in expediting the disposition of the action, discouraging wasteful pretrial activities, and improving the quality of the trial. Plaintiff's motion for early disclosure should be granted because the court would benefit. Defendants would not be prejudiced because they are required to provide this information very early in the action anyway. Plaintiff would incur substantial financial hardship without such early disclosure. How? What financial hardship? I mean, how? And the disclosure would not violate any attorney work product privilege. So attorney work product privilege is similar to attorney client privilege. Basically, I, as an attorney, am scribbling down notes in a deposition. Those notes are privileged. They're my work product. Basically almost any of my work would be work product and privileged. There are exceptions, but we're not going to run into any here. But the big exception would be, let's say, a corporate in-house attorney. So an attorney working for Google and employed by Google. So not the Weil Gotshal attorneys representing YouTube as external counsel in the Massachusetts case, but actually working for Google. Their day-to-day activities, even though they're lawyers, might not be covered by work product. They might not be, because it could be limited to work done in preparation or anticipation of litigation, I believe is the standard. It's been a while, so don't hold me to that too closely. So such early disclosure furthers the purpose of the rules cited above. Although plaintiff could not find a similar case in this circuit, courts have found in favor of similar early disclosure. See Resolution Trust Corp versus Heiserman, District of Colorado, 1993. So that's 10th Circuit. Nevada is in the 9th Circuit. The, this is just a poor sentence because you're drawing even more attention to it by saying, although plaintiff could not find a similar case in this circuit, just say, Resolution Trust versus Heiserman provides persuasive arguments for doing so. The judge knows what persuasive means. It's not binding. It's not mandatory. It means, hey, someone from a different circuit, different district, whatever, different state has recognized what I'm trying to argue for. But say, why? What was the situation there that warranted this? Make it fit your argument. You use the case law, don't just cite it. Plaintiff's motion for the extension of time to serve summons under FRCP 4 should be granted because plaintiff has been diligent. Defendants have withheld the true names, and plaintiff will need 90 days to serve defendants once they are named. This court has the authority to extend this time under the rules cited above, since this is for good cause. No. We'll get to why. We'll get to why. Believe you me. Hell, the court already has. Plaintiff's motion to amend its complaint under Federal Rule of Civil Procedure 15 solely to use the defendant's true names should be granted for the same good cause and in the interest of justice under the rules cited above. Plaintiff is unable to include the amended pleading due to not yet having the true names. It will be the most expedient to amend the complaint with true names before beginning service of process. Conclusion. Plaintiff prays for this court to grant an order or orders for defendants to provide a list to plaintiff for the full names and addresses of all named defendants, extending the time for plaintiff to serve summons to 90 days after it receives the above list of full names and addresses of all named defendants, and leave for plaintiff to file a first amended complaint solely to replace named defendants with their true names. I declare under penalty of perjury that the foregoing is true and respectfully submitted by Jose Decastro, pro se plaintiff, on April 28th, 2023. Moving on. We're just going to speed through what he filed. And I should have scrolled down on all of these before I went live to get rid of his personal information. You can tell I didn't read these ahead of time. As if I had, I would have noticed that these are three copies 3 copies of the exact same motion. Are you kidding me? And you'll see why I did this. So this is docket 10. This is docket 9. And this is docket number 8. Going to the docket 8, motion for early discovery. Docket 9, motion for extension of time to serve process. And docket 10, motion for leave to file first amended complaint. If you're going to file each of these as separate docket entries, split them up. Honestly. On the bright side, that's 4 pages to read instead of 12. So, hooray. But we have docket number 12. There's probably a docket number 11 somewhere that we haven't seen yet, that hasn't popped up on here. Or there was a numbering error, but whatever. So docket number 12 is the judge's order. As such, it says, order. It is hereby ordered that plaintiff's motions for early discovery, extension of time to serve summons, and for leave to file first amended complaint, 8, 9, and 10, are denied. Imagine that. Now, the court actually gave us a 2-page decision about why. Now, this is a spoiler alert for one of the upcoming videos. So, for those of you who are being very naughty and actually looking at the documents yourself before I cover it, one of his recent motions in the California case has a checklist for the judge, and it's ridiculous. But the idea itself isn't completely wrong. I think the execution is terrible, but so often, and I've actually what case was it? One of my more recent videos, I don't think okay, it was Schofield, the TikTok psychic case. I read the judge's order in that one, and you all should be watching those videos, because like I get 10 times as many views covering this moron as I do covering other morons. I think Delete Lawz is the least interesting of the people I'm covering. The TikTok psychic case is fascinating and much more entertaining. But I was reading the order, and I had to think about it for a second, thinking, now, did the judge write it? Did the clerk write it? Or did Professor Schofield's attorney write it? Because you'll often see after a motion, but it's usually there will have been an in-person hearing, or, well, at least a oral hearing. A judge will make their decision from the bench. They'll announce it, and then to the winning party's attorney, they'll say, you know, I'm sure you've all seen Judge Middleton in St. Joe County, Michigan, turn to Debbie Davis and say, Debbie, write an order and submit it. And so the winning attorney writes the order, and then the judge signs it. But for sort of easy motions that don't require analysis, that are like a motion to withdraw, let's say, if a case is over, I'll submit a motion to withdraw because I don't do post conviction work. So I'll submit a motion to withdraw so that I'm done with the case. The judge takes me off of it. I'm no longer responsible. And with that, I know the judge is going to rubber stamp it. So I will submit the motion with the proposed order. And then the judge takes it, signs it, stamps it, whatever, and submits it as the actual order. So Delete Lawz didn't submit his checklist as a proposed order. It's just part of his motion. But we'll get to that in a future video. Like I said, I just can't right now. It's so much nonsense. Unfortunately, Delete Lawz is not a JD. He's a PhD, in that his nonsense is piled higher and deeper. And the more I delay on covering that case, the higher and deeper his BS gets. And so I will get to it eventually, or back to it. I just can't right now. But that being said, that was a whole big tangent. But this is the judge's order. And this was clearly written by the judge or the judge's clerk, not by Delete Lawz, not by LVMPD's lawyers, because they haven't been served, I don't think. So, thoughtfully captioned order. Before the court are plaintiff's motions for early discovery, extension of time to serve, summons, and for leave to file a first amended complaint, ECF numbers 8, 9, and 10. The court denies plaintiff's motions as they are premature. It's that easy. That he's so early in filing this that it's like, so you mean to tell me you still have 80 days to serve the defendants, or 60 days or whatever, and you need an extension already? No. Just no. That's ridiculous. Plaintiff's request for expedited discovery is premature as no defendant has appeared in this matter. So LVMPD hasn't even appeared yet because they haven't been properly served, I don't think. And yet he's like, well, they've got to give me this in discovery eventually, so I want it now. I want them to give me the names of everyone now. But just like Veruca Salt, he's standing on that scale and it buzzes no because he is no golden egg, and it flushes him. This being Vegas, would you guys go to a Willy Wonka themed casino in Vegas? Either way, While LVMPD was served on April 28th, 2023, the response of pleading is not due until May 19th, 2023. So the court is just taking him at his word that they were served. Like I said, I don't think they were properly served. Now, whether they make an issue out of that, I don't know. But they very well could say, no, try again. Because even if it's just to be petty, just to cost him an extra $85. If they haven't been served, they haven't been served. The judge isn't looking at it specifically right now because LVMPD isn't arguing it right now. She's just taking him at his word right now. So it says right here that they were served on the 28th and responsive pleading is not due until the 19th. But that might not be accurate. Under Federal Rule of Civil Procedure 26F, the plaintiff and the first appearing defendant, here presumably LVMPD, must meet and confer to establish a discovery plan and scheduling order. Plaintiff may seek expedited discovery at that time. And if discovery cannot be agreed upon, the plaintiff may file a motion seeking such discovery. Plaintiff filed his complaint on April 17th, 2023. Under Federal Rule of Civil Procedure 46M, plaintiff has 90 days from the date of filing to serve defendants. There are 76 days remaining within which plaintiff may serve the yet unserved defendants in this matter. Thus, plaintiff's motion for extension of time to serve summons is premature. If service is unsuccessful after reasonable attempts are made and the 90 days within which to serve is about to expire, plaintiff may then seek an extension of time to accomplish service. Finally, plaintiff's leave to file first amended complaint is denied. Under Federal Rule of Civil Procedure 15A1A, a plaintiff may file an amended complaint within 21 days of serving his initial complaint without leave of court. In this case, plaintiff has until May 8th, 2023 to file an amended complaint. If plaintiff fails to file an amended complaint on or before May 8th, 2023, plaintiff may then seek leave of court to do so thereafter. Federal Rule of Civil Procedure 15A2. Because remember, we have all this from the Massachusetts lawsuit. Within 21 days, you can file an amended complaint as a right. After 21 days, or for a second amended complaint, you have to ask the court's permission. Why is he asking the court's permission if he has a right to do it anyway already? And that's what the court's saying here. We're denying giving you permission because you can do it anyway, dummy. Accordingly, it is hereby ordered that plaintiff's motions for early discovery, extension of time to serve summons, and for leave to file first amended complaint, ECF numbers 8, 9, and 10 are denied. Dated the 2nd day of May, 2023, Elena J. Yuga, United States Magistrate Judge. So there you have it. It's as simple as that. He he's premature. I'm guessing. Well, I was going to make a crude joke about it not being the first time he's been premature or heard that he's premature, but that would assume there has ever been someone to inform him he's premature, which not that there's anything wrong with that. But yeah. So that's the end of the analysis for today. So going forward, like I said, that there's an awful lot of content there in California that is going to break me. I'll get to it soon. There's probably 2 videos worth already, 2 longish videos. And since I get ad money per video anyway, what's the point in doing a 4-hour video instead of 3 hour-and-a-half videos? You know? Especially if it's going to have me banging my head against the wall. But I'm going to reach out to Natalie Lawyer Chick. I'm sure you're all at least aware of her, if not subscribed to her. But I just watched her video today about her recent adventures in court, and I'm going to reach out to her and ask her to send me those documents, because even though she has already covered it, and very well, I might add, you should all go watch it and subscribe to her and, you know, all that fun stuff. But even though it's doing something that's already been covered, I still want to do it myself because I want to highlight it as what excellent, just absolute perfection looks like when it comes to legal writing. Natalie is brilliant. And I'm not just saying that. Natalie is a brilliant attorney. The plaintiff's attorney in that case, less so, but you compare, like, you put the plaintiff's attorney in the place of Delete Lawz and Natalie in place of Blue Bacon or Benjamin Wish or Joshua Garrick or anyone who has written responsive pleadings in the cases we've looked at with Delete Lawz. Natalie blows all of them out of the water. And that's really why I want to cover it, just as an example of the best legal writing. So hopefully she'll agree to send it to me. I know I could go, you know, it's public record. I could go to the Michigan court pages and find it, but it's easier to just ask Natalie for it. Even though she doesn't owe me anything, she's never met me. I've been watching her channel since she was about my size of channel. So, you know. But that being said, do like, share, subscribe, do all that jazz on your way out if you didn't already on your way in. And I will see you very soon for the next one. Thanks for joining me. Bye-bye.